Hello, my name is Lisa Mart, and I am the Human Resources and Management Advisor for Iowa Municipalities Workers' Compensation Association. Today, we are talking about the different types of assessments, pre-employment assessments, and when you can use them in the hiring process or the employment process. The reason we have delved into this topic is many of our members have a hard time knowing if and when they should subject their applicants or employees to an assessment or a physical. They and their governing bodies sometimes are shocked and dissuaded by the time and cost that go into an assessment or evaluation, and they really are unsure what the reason is that they need to do it. What is the purpose? What is the value? What is the return on investment? Today, we're hoping that we're able to provide information that provide more knowledge to you about the different rules and regulations that govern assessments and physicals, the different stages which assessments are allowed and what assessments are allowed in those stages, the types of assessments out there, commonly used ones, and really why does it matter? Why are assessments and physicals important in the employment process from pre-employment to employment? Just a little education about, you know, the importance and the usage and the value. So to start out, we are going to talk about the rules and how to follow the rules. The Equal Employment Opportunity Commission oversees the Civil Rights Act, the Americans with Disabilities Act, and the Age Discrimination Act. These are the rules that can govern uh, different types of discrimination in the hiring process or the employment process. In particularly, the EEOC provides guidance that disability related inquiries and medical examinations on their face value are improper if different stereotypes or generalizations are made about an individual or a specific disability. So, it is not prohibited to say that all diabetic employees are unable to drive a forklift. You cannot exclude somebody based on their general medical history unless it's business necessary or job related. But it usually comes down to the individual and their disability in the accommodation that they may or may not need. So these rules also say that if an individual does have a disability covered with the Americans with Disabilities Act and they are requesting accommodation, it is the employer or due diligence to accommodate that accommodation request, or at least have an interactive conversation about that accommodation request. And again, comes into play when we're in a stage that utilizes medical examinations and physicals. So we'll talk a little bit more about that and what stages allow that and what stages do not. It also the laws say that it is illegal to retaliate against somebody for having a disability and for asserting their rights under the ADA or ADAAA. It prohibits discrimination against a qualified individual with a disability. It prohibits discrimination against somebody with a protected class and or age discrimination. And really those come into play with certain type of assessments. If the assessments that are being done, either specifically or, generally or just by chance end up discriminating against a certain class, then violation of these rules could occur. So if you're doing an assessment and people that are 50 or above are scoring poorly, that maybe the assessment that you're providing isn't structured well or has not been validated. So inadvertently you could be, discriminated against somebody because of their age. Um, the ADA comes into play in various types of employment and state and local programs. So all local government, regardless of the number of employees, must comply with the ADA. Again, talking about undue hardships, if somebody wants to say that they cannot accommodate an employee because it's an undue hardship, they must be cognitive and they must really understand that for something to be an undue hardship, it must be significantly difficult or very expensive to implement. Now, I'm going to tell you, if you're having conversations with an individual about a disability or the need for accommodation, you should be talking to your employment attorney. These can be very sticky areas. I'm not an attorney. This is not legal advice because I'm not an attorney. Make sure you are protecting yourself and getting good information about how to handle these situations. We're talking more general in this presentation, not legal advice. I'm not an attorney. So, the stages. What are the different stages and what is allowed? So, there are three different stages for assessments in physicals. There is the pre-offer pre-employment, post-offer pre-employment, and post-employment. The pre-offer pre-employment is when no offer of employment has been made to an individual or an applicant. In this process or at this point in time, um, no medical questions are allowed in the screening of applicants. There's no physicals, there's no medical questions at all that are asked. In the post-offer pre-employment stage, there has been an offer of employment made, but oftentimes it is contingent on the assessment or the physical that's going to be assessed to that individual. So once that offer of employment is made or contingent, a physical can be done and medical questions or exams are permitted. Really, truly, I would say at this stage of the process, the employer has the most flexibility of the medical questions that can be asked because once you roll into the realm of post-employment, the medical inquiries or physicals that you can provide or assess to an employee are very limited and specific to an injury or an illness and not general at all. So those are just kind of the stages. We're going to talk a little bit more in detail about the various stages and what is allowed. So again, starting with the pre-offer, pre-employment stage, again, I'm going to stress there has been no offer of employment made. Nothing, nobody has been offered the job. Nobody has said you're hired pending this. This is when there are still potentially, a variety of applicants, or maybe you've weeded it down to your finalist and you're looking for ways to assess them, but no offer of employment is made, so no medical examination or questioning can be done at this point. The EEOC has said, though, that employers are permitted to do a strength and agility testing for pre-employment evaluation. So oftentimes, I would say the individuals that do this most for our members are that these are performed on police officers and firefighters. There's a lot of times there's a physical agility test, whether it's, running a certain amount of time or miles or, climbing stairs with an air pack in full gear for firefighters. It could be a type of firearm qualification. So there's various things that could go into this from the physical standpoint. Um, my understanding, and again, I'm not an attorney, so for sure check with your attorney before you would disqualify somebody in this stage. But, my understanding of the EEOC's guidance that is that because it's not a medical assessment or a physical, if a applicant fails the physical agility or the skills assessment or whatever assessment that is being provided that is not medical, then the employer has the ability to refuse employment to the applicants that fail these tests. If the employee or not the employee, the applicant is unable to perform the physical capabilities of the assessments or of the job, then the employer may refuse employment and not have to offer or accommodate the individual for the position because no offer of employment has been made and no medical exam has been done. So different type of assessments that could fall within this realm. When it comes to like a skills assessment, that could be cognitive ability. It could be a work sample assessment, a personality test, maybe a language proficiency test. Then, if you move into the physical assessment, we kind of talked a little bit about, what the firefighters or police officers may do in this assessment. It also could be the assessment of somebody's muscle or joint strength as it would relate to the position that they would be doing. So you wouldn't necessarily have an individual do an assessment on muscle and joint strength. The assessment wouldn't be the same for a clerical person versus a secondary roads person. To do that assessment, you would want it to be based on the individual's job and the strength or muscle capacity that they would need to do for that position. So, it's very important when doing some type of assessment in this phase that you have a good job description and physical demands and essential functions. So you're properly weeding out people based on the job, not just based on overall strength and ability. The psychological assessment, oftentimes, police officers may have to do the MMPI, the Minnesota Multiphasic Personality Inventory, which is an assessment for some mental, psychological type of assessment. So again, those are used pretty specific to law enforcement. I've heard that when used in other areas that you could have the potential of like being at risk for a law or a lawsuit because the nature of the assessment maybe isn't needed for your run-of-the-mill position. So the big thing, I guess, to remember again, at this stage, there is no medical inquiry that can be done, no medical assessment, no medical physical, no nothing. Again, I can't stress this enough. Work with your HR, work with your employment attorney. You can have a lot of great selection tools within this stage of the employment process, but you really want to make sure that the questions you're asking, the assessments that you are performing, the types of things you're assessing are not having an inverse impact on any member of a protected class. Because if they do, then you're going to see, violation of some of these rules, and you're going to be in a whole lot of trouble. So again, that's kind of why we went over the rules in general, because they have different interplay with the different stages of the assessment employment process. Next, we are going to go into the post-offer pre-employment exam. So this would be when you've made an offer of employment to an individual or individuals, and you are going to do an assessment, maybe a physical. You can do an employment medical questionnaire physical at this point because an offer of employment has been made. The important things to know at this point is that if it is a physical or medical inquiry, this is medical information. It needs to be kept confidential. It should be kept in its own file. It should not be kept in the personnel file. If you've made that offer of employment and there are like 3 different results that you would usually get in this type of assessment. Once a physical has been done or a medical exam, the results are usually yes, the individual can perform the essential functions of the job, or the applicant can perform the essential functions of the job with these reasonable accommodations, or no, the individual cannot perform the essential functions of the job. So, it's important to know that you can't discriminate against somebody if they have the ability to perform some of the functions of the job or the essential functions of the job, but with a reasonable accommodation. Again, this is where that ADA comes into play, and the reasonable accommodation, the interactive conversation, and not just automatically saying that you can't do the job or you're not 100% physically fit, so we're not going to hire you, because you've made that offer of employment and it is contingent on it's contingent on the physical. If they have the ability to do the job with some sort of accommodation, you have to do your due diligence to assess whether you can accommodate the position or not. And again, remember, undue hardship is really hard to prove. So if you're at this point and you get a assessment result where it says the individual can perform the essential functions, with X, Y, and Z accommodations, or they can't perform the essential functions, I would, at that point, for sure, be talking to my attorney about how to proceed down the path with that individual or that applicant. Um, the other thing is the GINA, or the Genetic Information Non-Discriminatory Act of 2008, basically says that if in this medical examination, you cannot inquire about family medical history. So you can get medical history about the individual, but you can't go back and ask about cancer or any type of medical history about their family members. It's not applicable, and it's not relevant, and it's not allowed. So then next we're going to post-employment physicals. Now, these are very much only able to be done if it's job related and consistent with business necessity. So as I said in a previous couple of slides, the medical information that can be asked at this point is much more limited. So you can really only do physicals on employees, current employees, if you have a concern that they are unable to perform the essential functions of the job. So this could be at the conclusion of a workers' compensation claim. It can be, if the employee has been out of work due to uh, injury or illness, and you want to ensure that they're able to do the job when they come back. Now, there is a little bit of an exception. If you're a large enough employer that has 50 or more employees and you have employees that are covered by FMLA, you can't do a physical before they come back while they're still under FMLA protection if their 12 weeks have not expired, because technically they are still covered by FMLA. So my understanding, again, and call your attorney on this, is if they come back to work and clocked in, then their FMLA protection has ceased. But it goes back to that you have to have reasonable concern that they're unable to do the job. So are they walking with a limp? Are they holding their ribs? Are they complaining that they hurt, or that they don't feel that they're ready to come back to work because their injury still hurts? They can't climb a ladder, or they're coming back, but they can't do X, they can't do Y. Then they're basically showing you that they are not able to do the job, and you have a right to do a fit for duty examination. Again, I'm going to tell you at this point, it's very important that you're contacting your employment attorney to make sure that you're doing this in the proper steps in the most adequate way. If this point, if you're going to send them for a fit for duty, you're going to send them to your provider and you're going to pay the cost. So again, at this point in the process, make sure you're working with your attorney to ensure that you are not violating any of the rules or laws that we talked about prior. So I talked a little bit about the fit for duty. So, a lot of times terms get thrown around, whether fit for duty or functional capacity, and people interchange those, or, say one for the other. But to really kind of spell it out for basic necessity, the fit for duty is usually employer ordered. So you as the employer would order a fit for duty. Again, we kind of talked about when you can order it. You can't just randomly say, because you're 55, I want to do a fit for duty. You have to have reason to believe that somebody is unable to do their job. And a fit for duty would measure somebody's ability to return to work. So after they've been off for a long period of time, or for a workers' compensation claim or injury, you want to make sure you have a really good job description with physical demands, because you're asking a provider to do a fit for duty based on, their ailment, whether it's their back, their shoulder, their knee, as related to their job. So the provider is only going to test the specific area where you have concern and as it relates to the position. So you really want to make sure that you have a good knowledge of the position and what's being done in that position, and you have it on paper so you can provide that job description to the provider doing the assessment. A fit for duty can be done if there's a change in somebody's health status that may or may not, that may affect their job performance. In a situation where an employee requests a reasonable accommodation, during their employment, it may be necessary to do a fit for duty to see if you are going to be able to accommodate or not. Again, before you do that, make sure you're talking to your attorney. I really can't stress that enough. And then, like I said before, it only can center, or the only thing that can be assessed in a fit for duty is the area of concern. So, if you have a concern for the mental health of an employee, it would only assess their mental capabilities. If it was a back injury, they could only look at the back injury. You can't do a full physical on somebody at that point of a fit for duty. So that kind of goes back to why we talked about, or when we talked about that the employee stage is really hard to do a full assessment. You're really limited as on gaining information on the medical aspect of an employee. So the functional capacity exam is usually requested by, an insurance adjuster, a workers' compensation adjuster, a case manager. Those are the individuals that would order a functional capacity exam. The reason that they would request that would be a reasonable expectation that an injury could result in permanent restrictions, potentially a pre-existing condition or a work injury result in permanent restrictions, and trying to determine which contributed to which. It's very important to understand that if it's, workers' compensation claim or case and the adjuster requests a functional capacity exam, you as the employer cannot utilize those results to make an employment decision. So, if it's found that the individual has a permanent restriction, that's not cause for you to make an employment decision. You're going to have to do your own due diligence and work with your own attorney together with potentially, the attorney, if there's an attorney on this case, or the claimant's attorney. And if there's not, you still need to work with your employment attorney about what you're going to do with that individual based on their, medical examination, their functional capacity exam. So again, this is just kind of hopefully giving you more information about, what exams are, what are physicals, when you can use them. Again, I'm not an attorney. I can't give you legal advice. I'm always going to tell you to call your attorney in these situations because it gets really sticky. So I'm sure at this point you're kind of like, why would we even want to do any type of assessment or physical? It just seems like it's costly. Here Lisa's telling us to call our attorney. She's telling us all the things that could go wrong. Well, why does it matter? It matters because, one of the highest business operating costs that an employer has is, and they have very little control over it, is their workers' compensation cost, or the premium, and how the mod affects the premium. So, as an employer, you just pay for workers' compensation insurance, but you really have a little control over it. But the things that you can control could make a big difference. And, assessments in both pre-employment and the employment process are very important to controlling those costs. Statistics show that employers are going to see a higher frequency of job-related, strains and sprains as the American workforce continues to decondition physically. We as a society are deconditioning. We're not as healthy as our baby boomers or the greatest generation. We're not doing as physical demanding jobs. So as we see that change, you're going to see employees not be as physically fit as potentially needed. So, assessments are needed. A pre-employment, post-offer, or pre-offer assessment is a great tool for providing a baseline as to what the applicant can do, or what they're able to do. What percentage is their shoulder at, their knee at? If you have an individual that through the assessment you find that they've had previous shoulder surgery and that their right shoulder is at 75%, if they get hurt while on the job at your workplace, the adjuster won't have to ensure that individual's shoulder gets back to 100% because it would never get back to 100%. because it was never at 100%, it was at 75%. Then they'd only have to make sure it got back to 75%. If you're not doing any type of assessment, then you're not going to know that that shoulder was only at 75%, and you would constantly be trying, or we would constantly trying to get it to 100, and it's not possible. So then therefore we would be paying out disability, and that would affect your premium, etc. So, it's important to get that baseline to understand the people that you're hiring, what their physical ability is, and, in protection for if something happens to them. But it's also important that, you realize that unfit employees, I know it, I know that there's a, a very hard recruiting process right now, and it's very hard to find qualified or even just workers in general. But I caution you about just taking anybody, because unfit employees are more likely to incur strains and sprains. And obviously that those employees that are more subject and unfit and have a higher chance of getting strains and sprains, whether work comp related or work related or personally related, they're going to be the individuals that are going to drive up the workers' compensation costs. And if it's not work related, but they're, unfit and get a strain and sprain on their own time, it's going to potentially drive up your healthcare costs as well. So you really want to make sure that you know who you're hiring and what you're hiring, so you're not paying for it in the long run. If you have somebody that's unfit and, is frequently getting strains and sprains, this could result in time away from work, which could then, result in loss of financial stability for the employer because you're working short. It could result in a lack of financial stability for the employee. They could be stressing because they're not able to work, or, they're not making a consistent income. And then in turn, that all can, like, lack of the person working or working short is lacks in productivity for the employer and for their coworkers that are working harder and shorter because their employee is not there because they're injured at home. It's really important to understand that according to the Department of Labor, employees that have been on the job for less than a year have more than, so if for employees that have been on the job for less than a year, 31% of the time away from work is accounted to strains and sprains. So, I can only just say, it's very important that you are able to assess and ensure that the individuals that you're hiring are able to do the job and able to do the job in a safe and productive way. You don't want them to get hurt, and you don't want them to hurt somebody else because they're unable to do the job. So in conclusion, this was just kind of a short overview over different types of assessments and physicals and tools you can use in the selection and employment process to ensure that your employees are fit and able to do the essential functions of the job. If you have questions, my contact information is above. I'd be happy to talk more in detail or answer your questions. But again, as you're going down this path, or you're looking to, implement or beef up some of the assessments you're doing, make sure you do check with your employment attorney to ensure that you're not violating any rules or regulations or laws, and to make sure that the processes that you're using are valid and you're not having any discrimination, whether intentional or unintentional, occurring. So I hope this helped, and please reach out to me if you have any questions. Thank you so much.